Yes.
Please proceed, Avneet.
Good. Yes. Good evening to everyone present here. I, Avneet Kaur, member of Sambhav Initiative and moderator for today's event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Siddharth Dave sir, and to all the participants in this 2 weeks national capacity building program on family laws, code practice, procedure, and drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy, and in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about judicial separations and restitution of conjugal rights. It is my privilege to introduce our distinguished speaker today, an accomplished legal professional whose contributions to the field of law have been both profound and far reaching. Sir is a first generation advocate who embarked on his legal journey in June 2006 at Honorable Gujarat High Court. Rising through the ranks purely on the strength of his dedication, legal insight, and unwavering commitment to justice, Sir has carved a niche for himself in a highly competitive field. At a remarkably early stage in his career, Sir was appointed as one of the youngest panel lawyers for prominent institutions, including universities, municipalities, and statutory bodies. While his initial practice focused on criminal and education litigation, his expertise soon broadened to encompass civil disputes, taxation matters, and arbitration. Over the years, his legal acumen has played a pivotal role in shaping several landmark judgments delivered by Gujarat High Court. Currently, Sir serves as the senior standing counsel for key government departments such as DRI Customs, CGST, and regularly advises leading public sector undertakings, including ONGC, the Gujarat Housing Board, and others in high stakes arbitration matters. His practice also extends to the Honorable Supreme Court of India, where Sir has recently secured a landmark judgment that affirms a crucial principle that an advocate appearing on behalf of an accused cannot be summoned by police authorities, a judgment that reinforces the independence and dignity of the legal profession. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you. Coming straight to the subject. Today the subject is drafting of a petition on two aspects. One is judicial separation, and second one is a restitution of a conjugal right. So let me first take to the subject aspect of judicial separation, which is prescribed and provided under Section 10 of the Hindu Marriage Act. So before coming to a subject, if a client would come to you, if you are an advocate and you are to prepare a petition for restitution of conjugal rights, if a client would come to you, you are required to see what is the provision under the Hindu Marriage Act, because restitution of conjugal rights is provided under Section 9 and judicial separation is under Section 10. So in view of the provisions of Section 10, judicial separation, it says every party to a marriage, whether solemnized before or after commencement of this act, may present a petition praying for a decree for judicial separation on any of the grounds specified in subsection 1 of section 13. If you are for a husband and you are to file a petition for judicial separation, you can file a petition, prepare a draft only on the ground mentioned under section 13, subsection 1 of the Hindu Marriage Act. However, if you are for a wife, then wife is also entitled, I may read further, section 10, and in case of a wife, also on the ground specified in subsection 2 thereof, as a ground on which a petition of divorce might have been presented. So, before preparing a draft petition, you are also required to see what are the grounds available to you for filing such petition under section 13, because if you are to seek a decree of a judicial separation under section 10, then it can be only on the grounds which are available under section 13(1)(a), 13(1) of the Hindu Marriage Act 1955. So it's section 13 of the act says that any marriage solemnized whether before or after the commencement of this act may on a petition presented by either of the husband or a wife be dissolved by a decree of divorce on the ground that the other party, then there are one, two, three. There are total seven grounds mentioned. So you are required to take instructions from your client that what are the grounds for your judicial separation. You can verify these grounds from section 13 also, and accordingly prepare a draft for a judicial separation petition. This petition can be presented before a district court or a family court if available in the taluka level. So section 10 says a judicial separation, a petition. Now let us come to the drafting part, because the subject is how to draft a petition under section 10. So if you we are to prepare a draft, I have shared some of the draft also, which also later on can be provided to you. We are required to keep in mind that we are required to take instructions from the client that what is the marriage life, what is the span of marriage, what are the facts of the case. As an advocate, if you are to file a petition under section 10, you are required to go through the provisions of act. What are the provisions, what are the grounds? Before even drafting a petition, you are required to take complete facts from the client. Then you are required to go through the relevant provision and relevant decision of the honorable apex court as also the high court, because sometimes it may happen that you may choose one or two grounds from section 13 as is available under the provisions of act. But if you are not aware about the latest decision of the high court or the supreme court, then you might fail and you might not get the decree in your favor. Therefore, even before preparing a draft, my request is what even I was doing at my initial days when I would get some matter, I would go to the library, I would verify latest decision on the subject. You can also search you can also search that by section 10 judicial separation, you would find number of judgments. Though there are less number of judgments as far as provisions of section 10 judicial separation is concerned, there are number of judgments as far as section 9 is concerned. But as far as judicial separation is concerned, there are less number of judgments you would find even in GLS, GLR, all in SEC, because there are no any such decision on record. So even before preparing a draft petition, you are required to take instructions from the client with regard to the marriage span and the details and the reason for which he or she wants a judicial separation. Judicial separation, there is you before while even preparing draft for judicial separation, you are required to keep in mind that the other side, when they would appear, he or she would appear after notice, you would be facing a counterclaim or another petition under section 9 or section 13, because we have come across a case where there is an application is filed under section 10 seeking judicial separation. Other side would come and seek a restitution of conjugal right, or would seek a ground, or would seek a divorce decree under section 13. So before preparing a draft, you are required to verify all such grounds available to you for filing or seeking a decree of judicial separation under section 10, because your averment would be uh, fatal to you if you would not make necessary averment in the initial petition and would raise such contention at the appellate stage when a such decree is passed in your favor, which is challenged before the higher forum. Because in number of cases, it is my experience that when we prefer a appeal against that decree and would raise a contention, the court would certainly come to us and would say that where is your contention in the petition, where is your such averment made in the original petition. So there has to be a enough pleadings. Pleadings means when you are preparing a draft, so there would be a cost item. Then my request is, though we are not saying such a part in the petition, but my request is while preparing the draft for any draft, not for judicial separation or a restitution of conjugal rights, for any draft, first after the cost title, say that what is this application. So if you are preparing a draft petition under section 10 of the judicial of the Hindu Marriage Act seeking judicial separation, after a cause title, original husband, wife, and cause title, first paragraph would be, before even first paragraph, you may mention that this is an application under, this is a HMP petition under section 10 of the Hindu Marriage Act 1955 seeking a judicial separation. This would be the title. Then after that, in the first paragraph, before even facts, there would be a first paragraph with regard to what relief you are seeking. So you can mention that this is a petition under section 10 of the Hindu Marriage Act 1955 seeking a judicial separation on the following grounds. So while reading this paragraph, the concerned judge who would be dealing with, who would be deciding this petition would get to know that this is the crux of the matter. So your first paragraph should be so specifically drafted that entire crux of your petition would be there summarized in that first paragraph itself. Then in second paragraph, you may say, you may bifurcate that brief facts of filing of the present petition or factual metrics of the case. Then you are required to state all these facts of the case. While pleading the factual metrics of the matter, you are required to take each and every facts detail from the client. Client may not be aware that he would not provide you all such details. Therefore, you are required to get the all the papers from the date when the marriage was registered till the last date when the last notice was issued or received by our client. All such details you can take from your client and arrange it chronologically. So it would help you in preparing a matter. You would not miss a single fact if you would arrange all such papers, all such facts chronologically. So first date would be from date of birth. Say date of birth is so and so. Then marriage is solemnized on so and so after attaining the age of majority, and then narrates all such facts chronologically. And then after completion of facts, you can state what are the grounds after a last paragraph of the fact, which would also include the ground for which you are seeking a decree of judicial separation. You may narrate a ground. So first part would be that a prayer that which you are seeking. Second, then factual merits of the matter. Then the grounds on which you are relying upon. So you can say that based on the aforesaid, referred set of facts and circumstances of the case, followings are the grounds on which you are relying upon. You may also mention one line that the ground set out here under is without prejudice to each other. So it may not harm you, it may not come in your way, because there might be any such grounds which you may raise, which you may have to face when other side would come and say, sir, this is the ground mentioned in this petition. So grounds would be such that based on which you are required to get this relief. So you would get that relief based on that ground. So plead all such grounds. You are not required to plead the judgments on the in the ground, but still, however, you can mention that relevant decision of the Honorable Supreme Court or Apex Court or the High Court are there online, which you are relying upon. You may take relevant paragraph from that judgment and quote and unquote copy paste also that ground after suitable modification in the ground. And after that ground, formal paragraph would be that what is the cause of action, because if the cause of action is not mentioned, you will have to face the proceedings of 711. So cause of action should be that what is the cause of action arose. Then a jurisdiction aspect, that the lastly they were residing here, or the cause of action arose within the territorial jurisdiction of this honorable court, and therefore this honorable court would be having the jurisdiction to try and decide these issues. Then all other formal paragraphs are also there which you were required to plead. But keep in mind, it may happen sometimes that one crucial point which you have stated in your ground, but it is not there in the pleadings. Keep in mind that grounds are not the pleadings. So pleading has to be specifically there in your petition. Pleading should be what is your contention on merits, what is the factual aspect. Suppose you are seeking a decree of judicial separation, and you are saying that my marriage was solemnized with the respondent on dated so and so, so and so. And after that, if there is no fact mentioned that what has happened thereafter, and straight away in the ground you have stated some cruelty and all other grounds, but if it is not there in the pleadings, you would be facing consequences. You would be facing with the opposite side that this is not the pleadings in the petition, and therefore you are not you would not be in a position to raise this contention. So therefore, raise all such contention. Pleading should be such that all the facts, including your grounds in the sense the factual grounds, not legal grounds. Factual aspects should be there in the pleadings. After that formal paragraphs, you may quote unquote the relevant provisions also, because the what benefit would be for quoting and unquoting the relevant provision is, while deciding your matter, the honorable judge would not be in a position to get, though all such books are available, but he will not have to find that book and relevant section also. So for the sake of convenience, you may quote unquote the relevant provisions also, along with that proviso is necessary, because in some of the provisions there would be a proviso which says that burden of proof is on whom, because it is normal law that the person who assert has to prove. So if you are filing a petition, if you are claiming something, then burden is on you to prove this fact. So while even drafting a petition, keep in mind that you are required to prove all these facts by leading evidence. So attach all such documents along with your petition with the list of dates and events which would be exhibited later on. So even while preparing a draft, don't think that this is the paper which I have received from the client, and this is the prepared draft format draft I have received from someone. Copy paste, then you have added something, and we have filed it in the court. Don't do this. Keep in mind that based on your pleadings, based on your evidence, you would be getting a decree from a court. So even while at the first stage of preparing a draft, keep in mind that what would be the result at the end of the trial, and which would be the evidence which would be there in your favor, which you would be in a position to prove the said evidence in your favor. And what is the evidence which, and what are the grounds, what is the evidence there on record, or other side would come and place on record which would go against you. Keep in mind all such aspect, and then prepare a draft. So there would be a chances that where you would succeed in the matter, because ultimately all such cases would depend on the evidence on record, which either proved by the evidence, by leading of evidence by the parties, or otherwise if it is admitted. Because if all of you have seen that section 58 of the evidence act, while preparing a draft, you would be mindful that you may not admit something which at the time of trial other side would require to prove this fact or disprove your fact. Because if there is any admission on your part, then section 58 of the evidence act says, if anything is admitted by anyone in any statement or any proceedings, then other side is not required to disprove this fact or prove that fact. He would succeed on only on the ground of your admission made in the petition. So be mindful and be careful while preparing a draft that there should not be any admission on your part which would come in your way at the time of trial. So after that ground and formal paragraph, there would be a prayer clause. Prayer would be an important part, because ultimately at the end of the trial, at the end of any proceedings, you would be getting relief based on the prayer. Because in Gujarati there is a say which my grandmother was saying कि माग्या वगर तो माँ भी ना पीसे. So there has to be a prayer in the petition. You are required to couch a prayer very carefully. You cannot add something or plead something in the prayer only on the basis of the pleading. Before adding a prayer, you are required to see the provisions of law. What is the latest law on the land on this subject? So, if I would pray something, it may not happen that I would not get this relief because there is a exact contrary decision of the Honorable High Court or Supreme Court on this line. So you are required to verify latest law on this aspect. You are required to verify the provisions of law because according to me, there cannot be any judgment contrary to the common sense. So if you would see section 10, the wording itself is very clear. It says that judicial separation means a party, husband and wife, are not in a position to live together, and therefore they have decided to live separately, and therefore they want something from a court so they can happily stay separately with the order of the honorable court. So there is a provision, there is a specific wording provided under section 10 that judicial separation. Then section 10 is so then also see, there is a difference between judicial separation and a divorce. A question would come then when I appear for the husband and would seek a judicial separation. Then someone from the other side from for the wife would come and say that I want a divorce because ground of a judicial separation petition and a divorce petition would be the same. So, therefore, you have to be very careful while drafting a petition for judicial separation because you are required to see you may not commit any blunder or commit any mistake which would help the other side in seeking divorce if at all you want only a judicial separation and not the divorce. See, there are difference between the judicial separation and the divorce. A judicial separation, an application for judicial separation can be filed under Section 10 of the Hindu Marriage Act 1955 any time after marriage. So, if marriage is solemnized in the month of September, even in the month of October also, any party means husband or wife, either party can file an application seeking judicial separation. However, this is not the situation in divorce. In the view of the provisions of Section 13, application for divorce under Section 13 of the Hindu Marriage Act can be filed only after at least 1 year of marriage. So there has to be some time of marriage life, and after that you can file an application under Section 13. Then judicial separation under Hindu Marriage Act is a temporary suspension of marriage. See, after some time, it may happen that the dispute between the husband and wife may resolve and they may decide to stay together. Then, in that case, there is a possibility. This is therefore there is a provision of Section 10 by which there is a judicial separation for a temporary suspension of a marriage. However, in a divorce matter, divorce is a permanent end of the institution of a marriage. So you can not undo that. Once a divorce decree is passed, it is final. Thereafter, the parties are not allowed to remarry in cases where there is a judicial separation decree is passed. So today, if I would apply for a decree, seek a decree for judicial separation, and I would think that once the decree is passed in my favor, and if I am a Hindu, I would get remarried with anyone. It is not possible. It is not permissible. Therefore, the parties are not allowed to remarry upon passing of a decree of judicial separation. However, if at all anyone, either husband or wife, wanted to remarry, they are required to apply under Section 13 and required to get the decree of divorce. So they can get remarried also. Then, decree of judicial separation can be rescinded through an application by either party if the court is satisfied. However, decree cannot be rescinded. There is no undo in these proceedings. You are required to follow the whatever the decree is passed. Then, under what circumstances either party can seek a decree for judicial separation? This judicial separation can be filed either spouse on any at any time after marriage. However, divorce can be filed after 1 year only. That I have stated. Now, if we would see, there are certain grounds for divorce as mentioned under section 13, and for judicial separation also, and there are procedure under the different act. So if you would see that under section 13(2), the grounds for divorce as given under 13(1) and 13(2) have been made the ground for judicial separation, while previously they were separate and different. Under section 10, either spouse can file a petition under section 13(1)(I) also. 13(1)(I), it means where any of the spouses voluntarily had sexual intercourse outside the marriage. I may not go in detail. If you can go through the provisions of section 13(1) and 13(2) also. 13(1) is available for both the spouses, husband and wife, while 13(2) is available only for wife. So on any such ground, you may file such a case seeking decree of a judicial separation under the provisions of section 10 of the act. However, there is a provisions of section 23 in a special marriage act. If you would see the special marriage act, section 23 says judicial separation. A petition, it also says on certain ground. I may read section 23. A petition for judicial separation may be presented to a district court either by husband or a wife on any of the grounds specified in section 3, 4 of section 27 on which a petition for divorce might have been presented, or B, on the ground of failure to comply with a decree for restitution of conjugal rights, and the court, on being satisfied the truth of the statement made in such petition and that there is no legal ground why this application should not be granted, may decree judicial separation accordingly. So you are required to go through all such provisions also, because it says that there has to be a ground mentioned under section 13(1), and it also says, I may read B again, on the ground of failure to comply with the decree for restitution of conjugal rights. So if there is a failure of a decree, implementation of a decree which either party would had got under section 9, then in that case also you can a party can apply for judicial separation, and the court, this is important, and the court, on being satisfied of the truth of the statement made in such petition. So it says that the truth and of the statement made in the petition. So you are required to make a specific statement while keeping in mind the grounds which are mentioned under section 13, and based on that you may get a decree of judicial separation. Therefore, what is important is the statement made on oath in the petition. And what court would consider is, along with your statement of fact, I may read again, satisfied of the truth of the statement made in such petition, and that there is no legal ground why the application should not be granted. So, court is required to consider that there is no any other ground but to believe your fact, and based on that the court may pass a decree of judicial separation. Then where the court grants a decree for judicial separation, it shall be no longer obligatory for the petitioner to cohabit with the respondent, but the court may on any application pass some any such order also. See, now there are different provisions under the different act. Therefore, the legal framework for Christian marriages and other personal matters of Christian community is primarily governed by the Indian Christian Marriage Act of 1872. However, when it comes to the divorce and the dissolution of marriage, the provisions are outlined in the Divorce Act of 1869. Under section 22 and 23 of the Divorce Act 1869, the Christian husband and wives have the option to obtain a judicial separation decree on the grounds such as adultery, cruelty, or desertion lasting over 2 years. So here the grounds are different, not 13.1 and 13.2 only. Grounds are different. This decree is akin to a divorce, means era 2, which separates the husband and wife, prohibiting them from living together but doesn't dissolve the marriage itself. Then the decree can be reversed under section 26 of the Divorce Act upon the request of the spouse of the party who initially sought the judicial separation of a decree. The request can be based on the ground of the absent party's absentee during the judicial separation proceedings. If the court deems it satisfactory, it can issue a decree to reverse the such separation. So there is a provision. Then in partial religion, the provision is different. In partial religion, marriage is viewed as a contract and is celebrated through a ceremony known as Ashirvad, during which a priest bestows blessing upon the married couple in presence of two Parsi witnesses. Under the Parsi Marriage and Divorce Act 1936, specific provisions were established to address issues like an annulment of marriage, divorce, and judicial separation, aimed at providing relief to a married Parsi couple. Section 34 of this Act allows for a suit for judicial separation, which can be initiated by any Parsi husband or wife based on the ground outlined in the Act for divorce under Section 32. These grounds resemble those found in the Special Marriage Act 1954 and the Hindu Marriage Act 1955. Then there are important judgments on this aspect. You can read the case of Narsimha Reddy, 1975 also. I will provide all the such details also. And after judicial separation in India, spouses maintain their property rights as they did before separation. So they would claim the right from husband property, even wife would claim the right in the husband property, and the husband would also claim the property rights, which is also intact, and all such rights are not affected. Only the decree of judicial separation is passed. Then there are other decisions also. If you would see, if you would file any application for judicial separation, you would be facing another litigation of Section 9 proceedings or Section 13 proceedings also. Now, as far as Section 9 restitution of conjugal right is concerned, it happens in many cases when any application seeking maintenance is filed by the wife. A respondent with a view to avoid such maintenance amount would file an application seeking decree of a restitution of conjugal right. So therefore, there is a latest decision of the Honorable Apex Court rendered in case of Reena Kumari alias Reena Devi versus Dinesh Kumar, reported in 2025, volume 3 Supreme Court cases, page number 33. This is very important because here in this case, a decree for restitution of a conjugal right was passed. This is very important case because in mostly every cases where a smart lawyer would be appointed by a husband just to avoid the maintenance, he would file either an application seeking divorce based on various grounds as available to him under Section 13(1) and 2, or would file an application under Section 9 seeking restitution of conjugal rights, and would say that I am ready to keep her. However, she is not ready to come back and she deserted the matrimonial house, and therefore the wife is not entitled to an amount of maintenance. That would be the contention for the husband. Therefore, a case which was decided by the Honorable Supreme Court, in that case, a dispute arose where the husband got a decree in his favor under Section 9 of a restitution of conjugal right. That decree was passed. Thereafter, the said decree was not obeyed, was not uh, received, or he wife has said that I would not obey that order, and this is not a valid decree, or he would not obey that order. In that case also, in this case of Rina Kumari, though there is a decree passed by the competent court under Section 9 of the Hindu Marriage Act of restitution of conjugal right, he did not go back to the matrimonial house. She filed an application seeking maintenance, which was under Section 125(4) of the CRPC before the competent court. In that case, husband appeared and said that, see, this is the decree of restitution of conjugal right passed. I am ready to take her back my home, but she is not ready and willing to come back, and therefore she is not entitled to an amount of maintenance. In that case, ultimately, the Honorable Supreme Court has held recently uh, on 10th of January 2025. The Honorable Supreme Court has held, I may read the relevant portion, merely merely passing of a decree for restitution of conjugal rights at the husband's behest, coupled with the non-compliance with the decree by the wife. So there was a non-compliance. The Honorable Court has also noted this aspect. There is a non-compliance of a decree at the hands of the wife. Despite this, the Honorable Court has held that this would not by itself be sufficient to attract the aforesaid disqualification under Section 125, subclause 4 of the Code of Criminal Procedure, and disqualification has to be determined on the strength of the material and evidence available by examining whether the wife still had a valid and sufficient reason to refuse to live with her husband despite existence of restitution decree. So the argument that finding of restitution of conjugal right proceedings are binding on the court, cease of maintenance proceedings under Section 125 of the CRPC held not tenable and rejected. So even if a decree under Section 9 is passed and a wife is not ready to abide by it, abide the decree, then also in that case option is still with the wife to not to obey that decree. However, the wife is required to give the reasons for it and can claim the maintenance. This is the latest law. There are other judgments also which in detail discuss the section 10 and 10 of the Hindu Marriage Act. I may give the details of citation only, may not read the citation. One of the case wherein the discussion of section 13, the differences between the divorce and decree of separation as under section 13 and 10 is also referred in one of the judgment of Sujata Uday Patil, reported in 2016 volume 13 SCC, page number 272. Then another decision is of Sounder Gopal, 2013 volume 7 SCC, page number 426, wherein also the Honorable Supreme Court has detailed this aspect in detail and this is the case wherein a decree was passed by the Honorable Court under section 10 and the one of the party was residing outside the India. So question has come before the Honorable Court whether such a decree is binding to him or not. In that case, the Honorable Supreme Court has held that the Hindus domiciled in India, even if residing outside its territory, then also applicability of 1955 Act to claim of abandonment of domicile of origin India or intention to acquire domicile of choice. Then also this decree is binding to him, and it is held that right to change domicile of birth is available to any person not legally dependent, and such person can acquire domicile of choice by residing in the country of choice by establishing their intention of continuing to reside there indefinitely. Unless proved contrary, there is a presumption against the change of domicile, and person who alleges has to prove the same. And it is held that residence for a longer period is evidence of intention to change the domicile, so it also change the nationality, and ultimately it is held that this decree is binding to him, and it can be executed. So these are the provisions and these are the judgment of the Honorable Supreme Court. And as far as the draft petition of Section 9 is concerned, for seeking restitution of a conjugal right, I have provided this draft also, that you can file this petition before the concerned family court at a district place under Section 9. And I have provided this draft also, which you can go through just to save the time and couch the prayer accordingly. So I would raise here if any query, if any question, anyone can ask.
Sir, thank you very much for such a nice session. Now I would like to invite all participants. If you have any question, then they can directly unmute and ask to sir, and you can write in chat box as well.
Yes, Advocate Vasanta. Yes, Advocate Vasanta. Yes.
Good evening, Siddharth sir.
Good evening.
Thanks for the detailed explanation on judicial separation and restriction of conjugal rights, sir. Sir, I have a doubt, sir, regarding what if the husband do not comply the order of the restriction of conjugal rights?
There
Sir?
is, for non-compliance, there is no any such provision. Restitution, it is it is the choice of the wife. Wife can decide separately. As far as that that judicial separation part is concerned, it is for a temporary nature. If the husband is not ready, then the wife can also file a petition seeking divorce. That is also stated in one of such judgment, that if the husband is not uh, complying with, or wife is not complying with, then another party can also file a seeking divorce petition.
So,
And
sir, I have read somewhere. Sir, I have read somewhere if a husband do not comply the restitution of conjugal right, decree of restitution of conjugal rights, attachment of the property or imprisonment. Is it true, sir? Because I have read somewhere either he'll be imprisoned or his property may be attached if husband do not comply the restitution of conjugal rights.
even in case of wife also, the wife would not comply with, or husband would not, you can initiate any proceedings, but I don't think that attachment order, I will also I will check and come back to you. Otherwise, this is the temporary in nature. If the husband is not complying with the decree of separation, see, there is a difference between the restitution of conjugal right and decree of separation.
Yes, sir. My question is with regard to restitution of conjugal rights, sir.
Yes, I thought judicial separation.
No,
For
no,
restitution of conjugal rights, yes, the action can be initiated, not for the for judicial separation.
okay, thank you, sir.
Yeah, next, Anand Kumar.
Sir, in case one party has applied for a decree of judicial separation,
Right.
simultaneously the other party requests for a divorce, then which one will be adjudicated at that point of time?
Both would be executed. If both would be at a different place, mostly wife is filing a transfer petition, and it can be decided at one place. Therefore, I said you have to be very careful while drafting a petition.
Sir, my question is that if both have done, then court will take cognizance of what? Divorce or the judicial
Both
separation?
cases would be decided mostly by the very same court, because there would be a transfer petition either by the wife or husband.
And sir, in the last answer, when you suppose the same continuing, because I couldn't get clarification on that. Suppose there is a restitution of marital rights, and the husband has refuses to it. So, as per the discussion, uh, proceeding for his arrest and other thing can be started,
There
while
is
it
a
will not be
judgment
for
where
the woman.
imprisonment is there and property also can be attached. There is
But then the same,
but that decision is on the facts of each case.
sir, the same thing should be for the woman also, because it has to be
Yes,
gender
yes,
neutral.
both law would be applicable for both. Woman would get only some more grounds, nothing else. Decree would be binding to all, and it can be executed, and any penal action can be taken against both wife and husband both.
Thank you, sir.
Yes, any other participants? Please raise your hand. Sir, one of
Sir,
the question, sir, how to get the transfer petition in favor when the party has filed the case just to harass in-laws, especially by the wife?
See, in normally all such cases where the transfer petition is filed, my experience says that in the High Court also, where the wife would be residing, the case would normally would be transferred at the place where wife would be residing, because there might be another cases pending. And as far as the Honorable Supreme Court is concerned, in most of the cases where a transfer petition is filed by the wife, mostly it would be allowed, because in these proceedings of transfer, conveniency of wives is to be seen.
Yes, Sumit, are you there? Sumit. Yes, Sumit.
Good evening, sir.
Good evening.
Sir, like the previous participant has asked, but still I would like to, for my own clarity. For example, if husband file a case for divorce, contested divorce, and the wife file it for the restitution of conjugal rights. So, being wife a woman, will she get some kind of a favor from the court because the husband has filed for the divorce and the wife has filed it for the restitution of conjugal rights? How that case will be managed?
No, case would be decided on the pleadings, facts of the case. Therefore, if you would see all such judgments, it would be facts of the case. Therefore, there is an importance of the pleading.
Sir, will it not be factor who approached the court first?
No, no, sir, no, sir, no, sir. Case would be decided on the facts and circumstances of the case based on evidence only. It doesn't matter who would come first.
All right, thank you so much, sir.
sir, you have mentioned that no admission should be made. Does it apply to all other
Yes,
petitions,
it
sir?
would apply in all such proceedings, because in many such cases where there is no defense for the other side and where I appear for the defendant or respondent, I would be finding some admission in the pleadings and would refer to section 58 of the evidence, which specifically says that fact which is admitted need not to prove.
Yes, sir. Yeah. Thank you, sir.
There is a provision under section 58 of the Evidence Act.
Next question, participant. Sir, can divorce file under 13 be added with restriction of conjugal rights under section 9 later?
Sorry, I didn't get it.
Yes, sir. Can divorce filed under 13 be added with
Two.
restriction of conjugal rights under section 9 later on?
Later on, a party can file an application. There is no bar of filing any such application at any stage.
Okay, sir. Yes, sir. Anand Kumar, you have raised your hand.
Good evening, sir. Two questions. One, where is there any place where we can find the total number of divorce cases pending in India in respective high courts and all, so that there can be a data that things are pending for 7 years, so many cases, for 5 years, so many cases. That is one. And second, in that draft when you have made, is it okay in a draft if we put a flowchart kind of thing, or something more figurative, which immediately becomes very apparent, because most of the drafting which I see, it is in a paragraph and you keep reading the entire thing. But if there is a procedure, or if it is allowed that we make one small graph where it can be flowchart kind of thing documented, is it okay to include, or it is against the norms?
No, no, you
Thank
can
you, sir.
include it. Flowchart, you can include it. Otherwise, for all such documents, there would be on first page there would be an index showing all such documents. You can also prepare a flowchart showing that this is the details which I am relying upon this document for this purpose only. So it would help you, and it would also save the time of the court.
And about the first question, sir, where can we get from? Is there any database like this?
It is available on the Google. You can Google it also. It is always available.
No, sir, because I was planning to make a, search paper kind of thing, wherein try to establish that, for 5 years, so many cases in different high courts, for 7 years, for
Sir,
10 years.
my experience says that the person who has filed such petition has been saddled with heavy cost, and the petition is dismissed with exemplary cost, because all such courts are flooded with the cases which are pending.
No, sir, because this somewhere affects the fundamental right, Article 21. The moment a petition is filed, from
Yes.
that time, if for 5 years, 7 years, 10 years, it is languishing, somewhere it is affecting the basic fundamental right to live with dignity of both the parties. Now, court has to consider that also, and if there are issues, we have to find some kind of method where it can be reduced.
Sir, it depends on the cases. Suppose you are a district judge and you are having 5,000 cases. Out of 5,000, 3,000 are the cases in which the person is in custody. And in 2,000 cases, you would be facing an application from the party who would be seeking for early listing and early hearing. However, in a rest of 3,000 cases, since the persons are in custody, there is no family members and no one is filing an application. And the person who is filing an application is seeking expeditious hearing on the basis of their strength. The court is certainly would require to consider the application of a person who is in judicial custody and not the outside of the custody and seeking any relief.
Sir, sorry to continue with. My idea is that one wrong cannot make other wrong right. One person is suffering cannot say that because others are suffering, you also continue suffering. What I am trying to say is that in such cases where in India now it is on a rise, there
Yes.
are chances where people are exploiting this thing, and it is extending. What
Yes.
I am trying to say is that can there be a provision wherein if the marriage is broken beyond, any kind of reconciliation, it can be divided into two, three parts of this section. And people can be then, okay, your marriage is nullified. However, the maintenance and child custody can be decided so that at least you are free to live your life thereafter, rather than connecting everything together and making both the parties suffer. In that, one will be convenient, for one it will be not convenient, for 5 years, 6 years, 10 years, whatever. That is my primary thought process while writing this paper.
Sir, it is for the legislature to enact all such provisions. If you would believe this, I would believe this fact, because law does not come into effect where there is a goodwill. There was no such provision before 1955 Act. There was no such provision of that Divorce Act, because we used to believe the words of our parents. And as far as legislation and all such expeditious proceedings and the procedure is concerned, it is for the competent authority, Union of India or the state government to annex all such provisions. For us, what we can do it, we can appear in our cases and decide, take a decision in our favor. See, as a lawyer, if I am to appear before the court, if the court is not in my favor, I would go and seek an adjournment only. So all
sir.
are responsible for these pending cases.
And so Supreme Court recently might have, all of participants would have seen, the Supreme Court has become a court of matrimonial and bail court. They're listening only matrimonial cases
नहीं,
and
I
bail
would say
application.
as far as matrimonial disputes are concerned, why the people would approach the Honorable Supreme Court, because in view of the powers vested under Article 142, they would
Yes, sir.
get the
Yes, sir.
decree of divorce.
Yes, sir. And then always
Yeah.
irretrievable marriage. There is
Yes.
no need of cooling period. And
This
sir,
is
I
the
also
relevant recent case 2025 3 SCC. The Honorable Supreme Court said it was the restitution decree. The court has said that they exercise the power under Article 142 and a decree of divorce is passed.
yes, sir. Yes, sir. I also sir agree, because there is no need of fighting.
Yes.
It's not working. There is no need of go and have some time discuss like cooling period.
Yes.
Just say Tata bye bye and then
Yes.
and
Yes.
Anand Kumar ji rightly said like so many cases are things are there. But अगर नहीं चल रहा है so say Tata bye bye.
वो हमारे हाथ में है.
And then fighting for maintenance cases we can see.
Yes,
It's
that is right now not available,
sir.
sir. That is what I was trying
What
to
the-
say, that if this
Uh,
clause can be there, that after 1 year or 2 years, both are free to dissolve the marriage and live their life. Maintenance and child custody can continue, because when that happens, sorry to take 1 minute of time.
Yes, sir.
We hear story when two mothers said that this child belongs to me, and it was not proven. The king said that okay, cut the child in half and take both. So the original mother said don't do that. So when the marriage is dissolved, thereafter the ulterior interest is only child custody and maintenance.
Yes.
So that will get resolved immediately. Right now, because the marriage is not annulled, the other party says, okay, let him languish. He cannot live his life peacefully. He cannot move on in his life. And I am getting what I am getting. So if this thing can be seen in 3 different subsections when a case of divorce comes, I think it will fasten the thing.
Mm-hmm.
Thank you, sir.
Okay.
So we'll
Sir,
take up
there-
last question. Last
there are two
question.
questions
Sorry,
are
but
pending.
yes, madam, sorry for interruption.
Sir,
Sorry,
there are two questions being pending, sir, here.
ma'am, sorry, sir.
There are two questions pending.
Yes, you can ask.
Sir, બીજાના question છે. Sorry, can flat which is a husband's wife's name but paid fully by husband be decided by court in divorce cases? Wife has left matrimonial home with her paramour.
You are
That is
required to
the
see who has paid the consideration. It might be in the name of wife and anyone else.
So
What
paid
is
fully by
required
the
to be
husband.
considered is who has paid the consideration, because the registered document would be registered in her name. Therefore, even if the decree of dissolution or a judicial separation is passed, she would be the owner of the property.
Yes, Vasanta, madam, you can ask one question only because
No,
already
sir,
said.
there is a question pending here, sir, by Sumit, sir. Is restriction of conjugal rights maintainable by husband if wife has filed 498 IPC?
Yes, it is.
I wa-
It is maintainable.
Thank
I
you.
think, sir, yes. So I think, sir, we are done with all the questions. So thank you very much, sir, for your practical insight on this particular topic. And participant, please go through the draft shared by sir. I have already shared in the group. So thank you very much, sir, once again, and sir, look forward to seeing future events.
Thank you. Thank you.
Thank you very much, sir.
Thank you, participant, for joining. See you tomorrow.
Thanks.